Welcome to Compass and Clock. I'm your host, Mary Copeland. This infotainment podcast explores how to live your best life now and well into retirement. We'll discuss topics in financial planning, housing, and insurance. We'll talk wellness, relationships, and leisure activities. A full, active life requires planning for your goals and preparing for the unexpected. I'll introduce you to a variety of guests, from knowledgeable experts to folks sharing stories of their life experiences and so much more, because life is big. All is intended to help guide you in planning for what you need now and at any age. Like and subscribe so you don't miss a thing. Today, my guest is John Platt. John is the founder of Pro Fiducia Services, Inc. They are a firm that provides fiduciary services with discretion, trust, and integrity. This could include the role of a personal representative. John resides in Western Washington for the last 30 years with his wife and children, and he enjoys pickleball, golf, and the great outdoors. John, welcome to the show.
Thank you, Mary. It's very nice to get to be here.
Great. Well, John, today you and I are going to talk about the common estate planning documents and when they are effective and their importance. So I'm just going to roll right into the first question, if you don't mind.
Not at all. Ready when you are.
So in the introduction, the bio that I just said, I used the word fiduciary. What is the role of a fiduciary and what is its definition?
Fiduciary comes from the Latin word fiducia, which means trusted person.
Oh.
So a fiduciary is someone who takes care of, holds for safekeeping, perhaps manages property, perhaps items of some value that belong to someone else.
Okay. And if you're a fiduciary, how do you get appointed to be a fiduciary?
Well, very often, very commonly, when people are planning for later stages in their lives, or not necessarily later, unfortunately, but they are doing some what we would call estate planning. They're typically working with an attorney who is going to write for them 2 or 3 very common estate planning documents that describe what that individual wants to happen to his or her stuff in the event that he or she is unable to take care of those items for herself, if perhaps a disability or an absence, or worse, even death. And that's what estate planning documents are for. And a fiduciary is a trusted person identified in each of those estate planning documents.
So I did have a follow-up question to that, which was why are these estate planning documents important? So do you feel that you've answered both my questions, the role of a fiduciary, the definition of a fiduciary, and the importance of estate planning documents?
I would just add a little bit in that the importance of it is that here in the state of Washington, if someone dies without estate planning documents, there is still a need. If they die or they become disabled, there will still be a need for some sort of plan. And in the absence of a plan created by an individual and his or her attorney, then the state of Washington will create a plan for them. And it's if an individual wants to have some control, have some say over what happens to their stuff in an event that they can't act in their own best interest or on their own behalf, then the state of Washington will step in and make that happen for them. And it's probably not exactly what they would have done for themselves.
Okay. So we're doing a podcast right now, and with technology, our conversation and this educational half hour can be heard and seen around the world. With YouTube, locally on our public access station, and also listened to on podcasts. So outside of the state of Washington, there's going to be people listening. Does that hold true in other states, other
It
countries?
does. It certainly does here in the state of in the United States, and I would say in from what my knowledge of the little limited knowledge of, I'm not an attorney, so I don't know exactly how it's done in the legal world outside of the U.S., but I'm pretty sure in the British Commonwealth countries and other parts of Western Europe, there is a body of law that dictates and guides what happens to someone's personal property in the event that they are disabled or dead, and the disposition of that property. And that having someone appointed in advance of one of those tragic events is always wise, regardless of what country you live in.
So no matter where you live, folks, you want to put some type of estate planning documents in place.
Correct.
So, John, when it comes to these documents, can you, in chronological order, tell us where someone would start with these in planning these? Like, what's the first document they should make sure they have?
Well, I would actually say I would be say it's the power of attorney, honestly, the power of attorney for healthcare decisions. And I want to point out something important here. The power of attorney is the document, and the fiduciary person identified in a power of attorney document is very often referred to as the agent or the attorney in fact. But sometimes in our comfortable language that we tend to use, the power of attorney is the document, but it's also can be synonymous with the person who has the fiduciary duty. So for today's purposes, we'll just assume it's one and the same. But powers of attorney for healthcare decisions, I think chronologically, are really important and often overlooked, especially in young people. When we have, as I do, children in their late teens and early 20s, and they're at a stage in life where they're driving a lot and they're doing a lot of exciting, fun things, it's often overlooked that because they are adults, if they were to tragically find themselves in a medical situation, HIPAA laws would prevent the medical personnel that might be tending to their needs, would prevent them from being able to talk to me or my wife or anybody else's parents or grandparents, because HIPAA laws are built for that purpose, for privacy. And it would require a power of attorney for healthcare decisions to alleviate the risk on the part of the doctor or the hospital for talking to parents. And it cannot be assumed that doctors can talk directly to parents just because we're parents. Not anymore with the way the laws are. So chronologically, Mary, I would say get that power of attorney for healthcare decisions for your younger members of your family once they become adults. And
So
that
18
HIPAA
and
laws
older.
18 and older, exactly. Make that first on the chronological list.
I would have to, if I had to guess that a percentage, I would say it's a very, very, very low number that anyone between the age of 18 and 25 has a healthcare power of attorney.
I
But
would agree.
but it's people should start thinking about that. So you're hearing it here with John and I, healthcare power of attorney.
Yeah.
So healthcare power of attorney is also the next one. Would we be talking the next document? Would you want to be doing a financial power of attorney next?
I think so. I think while you're at it, and frankly, in working with an attorney who is preparing one document, may as well have that attorney prepare the other two important documents, which would be the power of attorney for financial decisions and the last will and testament. And I would suggest that do them all at the same time, but chronologically, the most important one is that power of attorney for healthcare for a younger person.
Okay. So that's power of attorney. And there is two ways you can look at this. you and I think, are on the same page. But when should a power of attorney become effective? Here, you just gave us a scenario that there are, once you're 18 years old, you should get one. But if you get a power of attorney and that document sitting in your invaluable documents file and it doesn't have an effective date on it, it's not very effective, is it?
Well, powers of attorney are typically written with language in them that describes when they become effective. And a lot of people will no doubt know that many, many powers of attorney have been written over the years that became effective upon the declaration of a physician. That the principal, the owner of that power of attorney, the person who's granting power of attorney, when that person is incapacitated upon the opinion of a physician, that's when that power of attorney document comes into play. However, it's becoming more and more common that powers of attorney become effective upon signing, upon when that principal, the owner who's granting power of attorney, the moment they sign it, the power of attorney becomes effective. And that opens up more opportunities for them to use that power of attorney for their benefit. And it makes it less ambiguous and reliant on the opinion of a physician who no doubt is going to be in a stressful situation at a time like something like that is needed.
I'm definitely an advocate of it being effective immediately, because otherwise, sometimes it's a two-step process to get it effective. And when it comes to somebody's healthcare and needing treatment right away, you might not have time to waste. So effective immediately is my vote.
Me too.
I've also heard the term DPOA, or durable power of attorney. So is a durable power of attorney and a power of attorney synonymous?
So they're not synonymous. The difference being that a general power of attorney, or just power of attorney, the powers granted by that document actually end at the moment that someone becomes disabled. Interestingly, and a durable power of attorney means that it endures an event. Its duration is through the period of someone's incapacity, and that its termination date is death.
So a power of attorney, I thought is only in effect while somebody's still alive. The same with the durable power of attorney. So you're saying a durable power of attorney terminates at somebody's death, but a power of attorney doesn't terminate at their death?
A general power of attorney will terminate upon. You did such a great job of looking this up for us too.
Okay.
A power of attorney
because durable power of attorney, the way that you said it, makes it sound like somebody could have an illness that winds up being short-lived and they're incapacitated during that healthcare crisis. And so that power of attorney is effective to help through it. But once the person has all their wits about them and they can, which should be any power of attorney, when you need help, it's there for help, and those people that are assigned can assist you. When you can take care of things yourself, you take care of things yourself. But once upon death, powers of attorney are ineffective.
So here's the definition I was looking for. A general power of attorney only operates while you are still coherent and mentally capable. It automatically expires upon incapacity or death.
Okay.
A durable power of attorney remains operational upon incapacity, although it does expire upon death. So the word durable means that it stays in place after someone has become incapacitated, declared as such.
Okay. Thank you for clarifying that for us.
You're welcome.
I do have another power of attorney question, and then we can move on to one of the other documents. But when you put a power of attorney into place, what's the rule of thumb? Should somebody be asked if they're willing to take on this role? Or should you just draw up the papers and they'll find out later down the road that they've been assigned? What's your thought?
Surprise. I can tell you from personal experience and many years of serving in this capacity that it's always better to uh, identify someone that you trust. Actually, I'm going to say someones that you trust. We'll get to that in a minute, and that you have some conversation with them, that they know that this could be coming into their lives at some point. Maybe it will, maybe it won't, but a lot of responsibility is being placed in their hands. It's not an insignificant duty, and someone should have the opportunity to agree or accept or decline to accept that responsibility.
I agree with you on that. And I guess I did have a follow-up question still, which was, with the power of attorney, do you feel that one person should be assigned for your power of attorney, or two people, more than one? And when selecting this person or persons, let's say you're a husband and wife, you have children, and your son became an attorney or a stockbroker and your daughter became a doctor. Would, if one's better suited for a role, should the daughter be the healthcare power of attorney and the son be the financial power of attorney? Do you have choices on how you do that?
You do have choices, and as I kind of alluded to a minute ago, I think it's always wise to have an alternate so to have a primary person, and for husbands and wives, it's typically each other. But we never know when this document is going to come into play and under what level of stress and grief people are going to be in at a time when suddenly they have this new job. And so it's wise to give that individual the option of relinquishing that power or sharing that power with someone that you've already chosen, with your alternate agent under that power of attorney. So having a second or a backup to the primary is always a good idea in any of these estate planning documents. And to your question about areas of specialty, I think that it's an excellent idea. We know that there are typically two powers of attorney, one of them healthcare related, and a family member is almost always the best choice for that, and a family member with a medical education and a capacity for advocating in a medical setting for their loved one is certainly going to be the best choice. I would say that powers of attorney for healthcare decisions very often are going to need to go to doctor's appointments. They're going to need to be on the phone or go to the hospital. And so some ability to be present, even if it's remotely, but to be present, to be in a close enough time zone, to be able to advocate properly with medical personnel that are caring for their loved one is going to be an important feature. Conversely, that power of attorney for financial decisions, if a family member is the choice and that person is perhaps employed in areas of finance and accounting and high level of organization and attention to detail, most likely their skills are going to make that kind of role for them, make them well suited for that kind of role. So,
okay. Well, I think we've covered power of attorney at the moment, and I'd like to roll into the last will and testament because we have a little less than 10 minutes or so. So I want to make sure we cover all our documents. So what is the last will and testament?
Last will and testament, also known by the shorthand of the will, is someone's memorialization of what they want to have happen to their stuff, their house, their car, their bank accounts, their personal property, what they want to have happen to their stuff in the event that they are deceased. And that last will and testament identifies a fiduciary whose job it is to execute. That's why they call them executors, is to execute the wishes that are outlined in that will as to what's supposed to happen to someone's stuff after they've died.
Okay. And I've heard the word probate thrown around. So if I have a will, does that mean I don't need to worry about probate?
So a will is actually, by definition, is what starts the probate process. And probate is a process of identifying a decedent's their assets, their liabilities, and the disposition of any debts owed and disposition of any assets to whomever they would want to have those assets after they've gone. And that is, in fact, the probate process. So a will creates the probate, and that's just part of the plan.
Okay. Thank you for clearing that up for me.
You bet.
So in talking about the will, you mentioned a person. So can you tell us what an executor is? And is executor synonymous with personal representative? And when does that position become effective?
So the executor is synonymous with personal representative. In Old English, the male fiduciary identified in a will was the executor. The female was the executrix. And in today's modern language, personal representative is synonymous with both executor and executrix. And they are the individual fiduciary identified in the will, in the last will and testament, as being the person responsible for opening the probate and going through the probate process and closing the estate of a decedent.
So it becomes effective upon death.
And it becomes
That position
effective
comes
upon
in.
death. Exactly.
Okay, so
It's
they take over after the power of attorney.
correct. Yep.
Okay. So you talked about in POAs where you can have an alternate. Can you talk about an alternate in a last will and testament? Does that?
I think that's a highly applicable time to have an alternate. None of us know, of course, what the circumstances are going to be at a moment of passing. And it could be that when someone sets up their will, they identify an individual. And it could be that at the time someone dies, that individual doesn't have the ability to act as the executor or as the personal representative. It may be a really difficult time for them. Maybe they've just taken a new job, or they've moved away, or the list of responsibilities at their current job has certainly grown, or any number of things. And so having an alternate already identified, already written into the last will and testament is peace of mind for the principal, for the person for whom that will is being written, but it's also a gift, if you will, to the personal representative who is in the first position. It gives them an opportunity to say, I know that I said I would do this, and but now is not a good time. And knowing that there is an alternate that's already been chosen makes it really easy for me to step aside and let that alternate person carry this project forward. And so therefore it's peace of mind for everyone in that regard.
Yeah, it's good planning, it sounds like, right?
Very good. It is. It's just very good planning.
So I've heard the word trust. What is a trust, and is it part of the estate planning documents?
So a trust can be, not always, but can be one of the estate planning documents. And a trust is an entity that is a repository, if you will, where someone can leave assets inside of a trust, and the beneficiary of a trust has the privilege, if you will, of benefiting from those assets. They don't own those assets, and it's a way to transfer the benefit of those assets to someone without burdening them with the responsibility of owning them.
And there's probably with the trust, there's maybe directions with it, like it's being left to this person. And upon the age of XYZ, they have access to it, or somebody's managing it for them, etc. So it usually comes with instructions, if I'm not correct.
That's correct. Absolutely
okay.
Correct. Yep.
All right. So we've got one final question for you before we wrapped up.
Okay.
We've talked about all these documents. Now, what do you do when you don't have a spouse, a relative, close friends, or neighbors to be appointed as your personal representative or your power of attorney? What's that person do then? Who can be these, take these roles on?
So I'll take them in a little bit of order. The power of attorney for healthcare decisions, I believe, is best served most of the time by a close family member, since it's such a personal role, knowing someone's individual health and being able to go with them to doctor's appointments. If there isn't a family member, then there are professional people who are care management or healthcare advocacy or otherwise caring people who can fill in to that responsibility if a family member is not available or not suitable for that role. Powers of attorney for financial decisions can be filled by an individual that a person trusts, that knows them to be competent at making good financial decisions. And there are businesses that can serve in that capacity, that for whom that is what they train for. It is for what they do as a regular course of their day-to-day activities, is to step into that role as the fiduciary and a power of attorney for financial decisions. And I would say similarly, the last will and testament. There are not always is there an available family member. Not always is there a family member that would be a good choice, perhaps, for a variety of reasons. And the benefit of being able to hire a business to step into that fiduciary role of personal representative is a step with a lot of peace of mind. It allows for someone to fill that role, someone who has the experience of having done it before, since most people have, and family members in that capacity typically have never done it, and they may never do it again. So it's very much on the job training. And people in that role who are family members also have no one else to do the job with them. They have no one else that they can delegate to. They have all the responsibility, and they're very possibly enduring some grief. And it's a difficult thing to do on top of their day job. So there are businesses out there that do exist for the purpose of being an alternate choice to a family member to manage the responsibility and see a probate or through completion.
So if there's somebody out there listening and you're on your own and you don't have a friend, a family member, anybody close by, there are organizations and businesses that are trusted that you can hire to be these, take on these roles.
Correct.
John, our time is up. So I want to say thank you for walking us through each of these very important documents. And let's reiterate, these documents should be done sooner rather than later and reviewed probably every 10 years approximately, or someone you named is no longer available, or there's been a big change in your life, make sure you get them reviewed. So thank you, John, for joining us. And until next week, everyone, take care and thanks for listening.
Thank you, Mary.
Bye-bye.